All right, this is chapter 6, and we'll be talking about legal and ethical issues that you may encounter during that psychiatric rotation. One of the goals of psychiatric care is to try to find a balance between the rights of the client and the rights of society at large. So, this chapter hopefully helps you understand and assist you in understanding the implications of ethical and legal issues when providing care in that psychiatric setting. As a psychiatric nurse, you will face legal and ethical issues during your practice. The fundamental goal of psychiatric nursing care is to find that balance between the rights of the client and the rights of society. Law and ethics are closely related because law tends to reflect ethical values of society. It should be noted that while you may feel obligated to follow ethical guidelines, these guidelines should not override the laws. Ethics is the study of philosophical beliefs. It's about what is considered right or wrong in a society. Bioethics is a more specific term, and it refers to the ethical questions that we see in healthcare. Law and ethics may be closely related because those laws often reflect what we want as a society as a whole. Legal obligations can be located in federal or state statutes, Board of Nursing regulations, or administrative code. You must familiarize yourself with all sources of nursing law in your state because they vary depending on the jurisdiction. Although they come from a variety of sources, we refer to collectively as the laws because there are legal consequences for violating them. Although you may feel personally obligated to follow ethical guidelines, again, these guidelines should never override the law. For example, if you're aware that a law prohibits a certain action, such as restraining a patient against their will, and you feel you have an ethical obligation to protect your patient by engaging in such an action and using restraints, you would be wise to follow the law. If you feel like you cannot breach your ethical standards to remain within the bounds of the law, you should immediately notify your supervisor. So, ethics is the study of philosophical beliefs about what is considered right or wrong in a society, while bioethics is a more specific term that refers to the ethical questions that arise in healthcare. And there are 5 basic principles of bioethics shown in Table 6.1. One of those principles is beneficence, and this is the duty to act so as to benefit or promote the good of others. For example, when we spend extra time to try and help calm down an extremely anxious patient. Autonomy. This is respecting the rights of another person to make their own decision. So the patient decides they don't want pain medication, and we acknowledge their right to refuse said medication. Justice. Justice is the duty to distribute resources or care equally, regardless of the personal attributes. So this would be something like devoting equal attention to both a friendly patient and a patient who's not making eye contact or speaking with you. Fidelity or non-maleficence. This is maintaining loyalty and commitment to the patient and doing no wrong to the patient. So we maintain our expertise in the nursing skill through nursing education. In other words, when we go in to do a procedure, we understand and we know how to do that procedure and we do it right so as to cause no harm or do no wrong to the patient. And then veracity, this is your duty to communicate truthfully, describing the purpose and the side effects of a psychotropic medication in a truthful and non-misleading way is one way we could provide veracity. So we're teaching our client about their medications and we truthfully tell them what the anticipated side effects are. Now, when we look at different admission procedures, we first will talk about involuntary admission. Involuntary admission can be made in the states if someone is deemed a danger to themselves or others, or if the person is not meeting their basic physical needs due to their mental illness. And the amount of time can vary from state to state, but it's usually somewhere between 24 and 72 hours. Now, in 1972, a gentleman was arrested for contributing to the delinquency of a minor. And rather than charge that person with contributing to the delinquency of a minor, which would have been a 1-year sentence, the state of Wisconsin elected to charge him with a sexual deviate act. And with the sexual deviate act, they could hospitalize him in a mental hospital for an unlimited amount of time. When that occurred, then this person came and filed charges against the state and against the hospital for holding them against their will for this unlimited amount of time and basically violating their liberty or their rights of liberty. So the Supreme Court ruled in favor of the client and stated that in order to involuntarily commit someone to a mental hospital, that it was considered a massive curtailment of liberty and that it would require due process. So in 1972, the Supreme Court held that involuntary civil commitment to a mental hospital is now considered a massive curtailment of liberty. It requires due process protections in the civil commitment procedure, and that due process is a legal term referring to the requirement of state and federal governments to follow fair procedures before they can deprive someone of liberty or property. The right to the due process also is derived from the 5th and the 14th Amendment in the U.S. Constitution. The 5th Amendment applies exclusively to actions of the federal government. The 14th Amendment extends due process to state actors. In 2001, the Supreme Court extended those rights to non-citizens as well. Now, the state civil commitment statutes, if challenged in the courts on the constitutional grounds, must afford due process protections to pass the court's scrutiny. This came about from scrutiny regarding a case with Zinnerman versus Birch, and this was more about a voluntary commitment. So in this case, this person, Birch, was found wandering along a Florida highway. They were injured, they were disoriented, and they were brought to a local mental health center where they were hallucinating, confused, psychotic, and they believed they were in heaven. And then later they signed a voluntary admission and consent to treatment. The client then sued the hospital several months later when they were discharged because they said that the hospital, the psychiatrist, and the team should have known that he was not capable or competent of signing an informed consent at that time. In due process, the governments have to allow for this fair procedure before they can deprive somebody of their liberty or property or life rights. And then we have writ of habeas corpus. And this is a formal quest that orders the custodian of the person in custody to produce the individual before the court and make an inquiry concerning their detention, to appear before the prosecution, and to appear or testify. So when the writ of habeas corpus is granted, it means you're granted another day in court. You're given another chance to prove that you're being subjected to unconstitutional conditions. And then we also have this court order that came about from the Supreme Court that states that the less restrictive alternative doctrine must be used, so that mandates that the least drastic measures must be taken to achieve a specific person. So again, if you were being hospitalized for something like depression, then if we could treat you on an outpatient basis, we would do that. We would treat you in the least restrictive manner possible. In the case of Olmstead versus LC, Supreme Court ruled that states are required to place patients with mental health needs in the least restrictive community setting rather than an institution. And this is based on the fact that the treatment professional has determined that the community setting is appropriate and the patient is not opposed. This is based on the fact that there's a medical standard or a justification for the admission. The illness must present an immediate crisis, and expectations exist that hospitalization and treatment will help improve the immediate problem. Voluntary admissions are usually sought by the patient or the patient's guardian, and there's usually a written application made to the facility. When patients are voluntarily admitted, they have the right to demand and obtain release at any time. Some states require voluntarily admitted patients be notified of the rights associated with their status, and some states require that a patient submit a written release notice to the facility staff, who then would re-evaluate the client's condition for possible conversion to involuntary status according to criteria established by law. When an involuntary admission is made, it is done so without the patient's consent, and it is done when a person is in need of psychiatric treatment because they present a danger to themselves or others. They're unable to meet their own basic needs due to their mental illness. Involuntary commitment requires that the client retain freedom from unreasonable bodily restraints, as well as the right to informed consent and the right to refuse medications, including psychotropic or antipsychotic meds. There are three different types of commitment commonly available: judicial determination, administrative determination, and agency determination. In addition, a certain number and type of physicians must certify that the person's mental health status justifies detention and treatment. Involuntary hospitalization can be further categorized by the nature and purpose of the admission, including emergency hospitalization, observational or temporary hospitalization, as well as long-term or formal commitment or outpatient commitment. Emergency hospitalization is used as an emergency type of commitment for a specified period or hours or days to prevent someone from engaging in a dangerous behavior towards themselves or someone else. Police officers, doctors, and mental health professionals are often designated by law to authorize the detention of someone believed to have mental illness who presents a danger to themselves or someone else. Those who undergo extended involuntary hospitalization or long-term commitment are committed through medical certification, judicial or administrative actions. Some states do not require a judicial hearing before commitment, but they often provide the client with an opportunity for a judicial review after commitment procedures. This long-term commitment for involuntary hospitalization generally lasts 60 to 180 days, but it can be for an indeterminate period. Long-term commitment for involuntary hospitalization has as its primary purpose extended care and treatment of a patient with mental illness. Beginning in the 90s, states began to pass legislation permitting outpatient commitment as an alternative to forced inpatient treatment. States have begun to use involuntary outpatient commitment as a preventative measure, allowing a court order before the onset of that psychiatric crisis. That would result in an inpatient commitment. The order for the involuntary outpatient commitment is usually tied to the receipt of goods and services provided by social welfare agencies, including disability benefits and housing. To access these goods and services, the patient is mandated to participate in treatment and may face inpatient admission for failure to participate. The American Psychological Association only approves this type of intervention for individuals with severe illnesses who are unwilling or unable to participate in voluntary outpatient care. Ideally, this should be a temporary condition, with the individual converting to voluntary therapy within weeks or months. Forced treatment often raises ethical dilemmas regarding autonomy versus paternalism. Privacy rights due to protect and right to treatment have been challenged on constitutional grounds. Discharge from the hospital would depend on the patient's admission status. If the client sought informal or voluntary admission as previously discussed, then they would have the right to request and receive release. Some states do allow for a temporary hold of a voluntary patient, so safety concerns can be addressed by the psychiatrist or psychiatric nurse practitioner before the patient is discharged. States may also provide for the conditional release of voluntary patients, which enables the treating physician or administrator to order continued treatment on an outpatient basis. A conditional release usually requires outpatient treatment for a specified period to determine the client's adherence to medication protocols, ability to meet basic needs, and ability to reintegrate into the community. Unconditional release or discharge is termination of a patient-institution relationship. This release may be court-ordered or administratively ordered by the institute's officials. The administration officer of an institution has the discretion to discharge patients. Upon admission, psychiatric facilities generally provide patients with a written list of basic patient rights. These rights are derived from a variety of sources, especially legislation developed during the 60s. Right to treatment. With the enactment of hospitalization of the Mentally Ill Act in 1964, the right to psychiatric treatment in public hospitals was created. The act requires that medical and psychiatric care and treatment be provided to all public hospital patients. Although state courts and lower federal courts have decided that there may be a federal constitutional right to treatment, the U.S. Supreme Court has never firmly defined the right to treatment. Based on several early decisions, treatment must meet the following criteria. The environment must be humane, staff must be qualified and sufficient to provide adequate treatment, the plan of care must be individualized. In 1975, Supreme Court held in O'Connor versus Donaldson that a state cannot confine a non-dangerous individual to a psychiatric facility if that individual can survive safely in freedom by himself or herself with the help of willing and responsible family members or friends. The law also said that the companion to the right to consent to treatment is the right to withhold consent. A patient may withdraw consent at any time. Retraction of consent previously given must be honored, whether it be verbal or written. The mentally ill's patient right to refuse treatment with psychotropic drugs has been debated in the courts, based partly on the issue of the patient's competency to give or withhold consent to treatment and their status under civil commitment statutes. Early cases initiated by state hospital patients considered medical, legal, and ethical considerations as basic treatment problems, the doctrine of informed consent, and bioethic principles of autonomy. For a summary of the evolution of one landmark set of cases regarding to the patient's right to refuse treatment, see Table 6.2. The notion of refusing treatment becomes especially important if we consider medication a chemical restraint. If it is, the infringement on a person's liberty is equal to involuntary commitment. As such, the non-institutionalized competent mentally ill patient has the right to determine whether to be involuntarily committed or to be medicated. Cases involving the right to refuse psychotropic drug treatment are still evolving. Without clear direction from the Supreme Court, individual states can continue to follow their own laws. The principle of informed consent is based on a person's right to self-determination as established in the case of Canterbury versus Spence, 1972, in the D.C. Appellate Court, determined that the medical provider has an affirmative duty to disclose all of the known risks and complications of a proposed treatment to allow the patient to make an informed decision as whether or not to proceed with that treatment. The standard was adopted nationwide. As a result of this ruling, proper orders for specific therapies and treatments are required and must be documented in the client's chart. Consent for surgery, ECT treatment, or use of experimental drugs or procedures must be obtained. In some state institutions, consent is required for every medication addition or change. Patients have the right to refuse participation in experimental treatment or research and the right to voice grievances and recommend changes in policy or services offered by the facility without fear of punishment or retaliation. For consent to be legally effective, it must be informed. Patients must be informed of the nature of their problem or condition, the nature of the purpose of the proposed treatment, risk and benefits of that treatment, and any alternative options that are available. Also, the probability that the treatment will be successful or not, and risks of not consenting to the treatment. The psychiatric nurse must know that the presence of psychotic symptoms does not mean that the client is incompetent or incapable of understanding. Neither voluntary or involuntary admission to a psychiatric facility determines whether a client is capable of making informed decisions about the health care they may need. Clients must be considered legally competent until they have been declared incompetent through a legal proceeding. Competency is related to the capacity to understand the consequences of one's decisions. The determination of legal competency is made by the court. If the client is found incompetent, then the court may appoint a legal guardian to be responsible for giving or refusing consent for the person that the court has found or deemed to be incompetent. If a clinician approaches a client with medication in hand and the client indicates a willing to receive the medication, then implied consent has occurred. State psychiatric hospitals generally require informed consent for every medication given. A general rule to follow is the more intrusive or risky the procedure, the higher the likelihood for informed consent. The fact that you may not have a legal duty to inform patients of the associated risk and benefits of a procedure does not eliminate your professional duty to clarify the procedure to the client and ensure their expressed or implied consent. So Bandy lives in a cemetery under a tarp. He scavenges for food around the local supermarket. Today, the manager of the supermarket calls the police. Upon arrival, they find Bandy pushing multiple grocery carts, agitated, his fingers bleeding. He tells the police, "I will have to scrub all the rust off these carts and all the carts in the world. Then I can be saved and go to heaven." The police bring Bandy to the community mental health center, discuss the patient's legal rights. Were the police justified in bringing him to the center? Explain your answers. Should he have been initially taken to jail? Why or why not? Which of the following applies to Bandy's rights as a citizen? A. His rights were violated. B. His rights were upheld. C. His rights were not considered. Or D. His rights were misinterpreted. The answer was B. His rights were upheld because he was deemed at risk of harm for himself. He wasn't really meeting his basic needs either. When Bandy was apprehended by the police, he was handcuffed and placed in the police car. Care was taken to ensure he was not injured during the process. The officers told Bandy he was being taken to a safe place. Upon arrival at the facility, Bandy was escorted to the emergency services area where he was assessed and admitted to the crisis stabilization unit. He was frightened, paranoid, and physically struggling with the mental health technicians, yelling, "I ain't finished my mission. The grocery carts are still covered in rust. I'm gonna die." As the nurse manager of the unit, how should you intervene, and what are your legal options and responsibilities? So what are the things you have to take into consideration here? Your client is frightened and paranoid. He's physically struggling with the mental health technicians, which puts both him and the technicians at risk for getting injured. He's having delusional thoughts, and he's not meeting his basic needs. So as the nurse manager, how should you have intervened, and what were your legal options and responsibilities? Upon entry to the crisis stabilization unit, Bandy was taken to the seclusion room and chemically restrained. What does this mean? A. He was medicated against his will. B. He was forced to swallow drugs. C. He was a victim of assault and battery. Or D. He was a victim of false imprisonment. So the answer here is A. Bandy was medicated against his will, and he was medicated because that verbal redirection, other things were attempted, but it wasn't successful. Which of the following applies to Bandy's treatment by the nurse manager? A. Legal protocol was followed. B. Ethical boundaries were crossed. C. The patient will probably follow a lawsuit. Or D. Informed consent was not obtained. A. Legal protocol was followed. Typically, medication is considered if verbal interventions fail. Chemical interventions are usually considered less restrictive than mechanical. So when we give a chemical, then we'll follow the protocol of monitoring this client's vital signs, monitoring for any sort of reaction to the medication, and monitoring them to show that they're showing signs of less agitation, less dangerousness to themselves or others. Manny has been observed in the seclusion room for the past 2 hours. His hygiene is very poor. He is drowsy with slurred speech. Vital signs are stable, and he states that he's hungry. What is the nurse manager's best intervention at this time? A. Ask the mental health technician to bring Bandy back to the room, to seat him at a table and offer him a snack. Offer Bandy a snack and ask the mental health technician to offer fluids and toileting, then medicate the patient as a precaution against his aggression. C. Ask the mental health technician to assist Bandy with the shower and return him to the seclusion room and then offer him a snack. Or D. Offer Bandy a snack and then assist the mental health technician in taking Bandy to his assigned room to lie down. Document the interventions and the outcomes. So your best answer here is D. Offer Bandy a snack and then assist the mental health tech in taking Bandy to his assigned room to lie down. Document the interventions and the outcomes. What makes the following the best answer? Offer Bandy a snack and then assist the mental health tech in taking Bandy to his assigned room to lie down. So that was the best correct answer because Bandy's been through a lot, so we're giving him a snack, and then we gave him this chemical restraint, so we want to take him to a quiet area, and his bedroom is going to be the best place for him to rest, so we'll take him there and we'll allow him to rest. Ask the mental health tech to bring Bandy to the day room, seat him at a table, and offer him a snack. Bringing him to the day room, there's other people there, and that may stimulate him or get him worked back up again. Offer Bandy a snack and ask the mental health tech to offer fluids and toileting, then medicate the patient again against again, as a precaution against his aggression. So we don't give people chemical restraints. This is a chemical restraint, and we don't give them as precautionary measures. The patient would have to be engaging in some sort of behavior that's dangerous to himself or others before we would actually administer it. And then ask the MHT to assist Bandy with the shower, return him to the seclusion room, and then offer him a snack. Because he's sedated, his speech is slurred, I would wait until he was less sedated from the medication, and we gave him the medication to calm down. Giving him a shower might stimulate him. So again, we're going to do other things to encourage rest at this time so that the chemical can really kick in and do its job. It's not unusual for a student or a new nurse to suspect negligence on the part of a peer. In most states, nurses have a legal duty to report any risk of harm to the patient. It's also important to document evidence clearly and accurately before you make an accusation against someone, especially a peer. If you question the appropriateness of a doctor's order or an action or those of a fellow nurse, communicate the concerns directly to the person involved. If the questioned behavior continues, you have an obligation to communicate the concerns to a supervisor who should then intervene to ensure that the client's rights and well-being are being protected. If there's not a supervisor on site, then you must communicate your concerns to the appropriate person as soon as possible. If you suspect a peer of being chemically impaired or of practicing irresponsibly, you have an obligation to protect not only the rights of the peer, but also the rights of all clients that could be harmed. Reporting also allows the impaired healthcare worker to receive treatment, and in many states they can retain their license to work under certain circumstances. If you have reported the suspected behavior of a concern to a supervisor and the danger persists, you have a level to report the concern to the next a duty to report the concern to the next level of authority. It's important to follow channels of communication, but also important to protect the safety of clients. If the supervisor's action or inaction does not rectify a dangerous situation, you must continue the duty to report the behavior of concern to the appropriate regulatory authority, such as the Board of Nursing. So in most states, you have a legal duty to report any risk of harm to the patient, communicate your concerns directly to the person involved. We're talking about peer here. If the questionable behavior continues, report the behavior to the supervisor or the appropriate authority. And if any danger persists, then make sure you report the concern to the next level of authority, such as the Board of Nursing. Discuss legal considerations of patient privilege after a patient has died, if the patient tests positive for HIV, or if the employer states a need to know. A person's right to privacy continues even after they have expired. You may not divulge information after the person's death that could not have been legally shared prior to their death, except with proper legal authorization. HIPAA protects confidential information about people even when they're not alive to speak for themselves. A legal privilege of confidentiality exists to protect the confidentiality of professional communications, such as the nurse-patient relationship. There are exceptions to privilege, and a healthcare provider may be compelled to provide testimony under subpoena. Furthermore, privilege does not apply in cases where the healthcare provider has a duty to report past, present, or future abuse or criminal activity. If a duty to report exists, you may be required to divulge private information shared by the client. Some states have enacted mandatory or permissive statutes that direct healthcare providers to warn a spouse if a partner tests positive for HIV or other sexually transmitted diseases. Nurses must understand the law in their jurisdiction of practice regarding privileged communication and warnings of infectious disease exposure, such as HIV. Any release of patient information to a third party, including the family or employer, without the patient's express consent is considered a breach of confidentiality. There are a few exceptions to confidentiality. California Supreme Court in 1974 decision of Tarasoff versus Regents of University of California ruled that a psychotherapist has a duty to warn a patient's intended victim of potential harm. A student that was counseling at the California University after being romantically rejected by Tarasoff told his doctor that he was upset by the breakup and planned to stab Tarasoff. The psychologist notified police verbally and in writing that the young man may be dangerous to Tarasoff and recommended civil commitment. The police questioned the student, found him to be rational, and secured his promise to stay away from his love interest. The supervising psychologist stated that commitment was not appropriate and that Potter should not be detained. Potter stopped seeing the therapist and befriended Tarasoff's brother to gain insight on her activities, eventually became his roommate, and Potter killed Tarasoff 2 months later in the same manner he described to his doctor. This case created a lot of controversy and confusion in the psychiatric community over breach of patient confidentiality and its effects on the therapeutic relationship, and also the ability to provide care over the ability to predict when a patient is truly dangerous. So this continues as other jurisdictions have adopted or modified the California rule despite the objections of the psychiatric community. The duty to warn usually includes the following: assessing and predicting the patient's danger of violence towards someone else, identifying the specific individual being threatened, and then taking the appropriate action to protect the identified victim. The California Supreme Court held that the protective privilege ends where public peril begins, signaling the concern for public safety. Any action reasonably necessary under the circumstances, including notification of the potential victim, the victim's family, and the police, discharges the therapist's duty to the potential victim. In 1976, California Supreme Court issued a second ruling in the case of Tarasoff versus Regents of the University of California. This ruling broadened the earlier ruling, the duty to warn, to include the duty to protect. Most states have similar laws regarding the duty to warn third parties of potential threats. Currently, 33 states have an affirmative duty to warn or protect, with an additional 11 states permitting a healthcare professional to break privilege to warn intended victims. The duty to warn usually includes the following: assessing and predicting the patient's danger of violence towards another, identifying the specific individual threatened, and then taking the appropriate action to protect the identified victim. In jurisdictions that have adopted the Tarasoff doctrine, duty to warn third parties is applied to the advanced practice registered nurse and the psychiatric mental health nurse. Staff, nurses, and members of the mental health team should report threats of harm. Failure to communicate and record relevant information from police and relatives may result in the patient's old records being deemed as negligence. So, as a staff nurse, what this means for you is that when a nurse does not report patient threats of harm against specified victims or classes of victims, this failure is likely to be considered substandard or negligent nursing and can lead to legal liability. The failure to communicate and record relevant information from police, relatives, or previous records may also be deemed negligence. Breach of the patient-nurse confidentiality should not pose ethical or legal dilemmas for nurses in these situations because the team approach to delivery of psychiatric care presumes communication of pertinent information to other staff members to help develop a treatment plan in the client's best interest. Child abuse and elder abuse. Because of the interest in trying to protect children, all 50 states and the District of Columbia have enacted child abuse reporting statutes. Although these differ from state to state, they generally include a definition of child abuse, a list of individuals required or encouraged to report abuse, and the governmental agency designated to receive and investigate those reports. Most statutes include civil penalties for failure to report, and many states specifically require nurses to report cases of suspected abuse. There is a bit of conflict between the federal and state laws with respect to child abuse reporting. When the healthcare professional discovers child abuse or neglect during the suspected abuser's alcohol or drug treatment, federal laws and regulations governing the confidentiality of patient records, which apply to almost all substance use and alcohol treatment providers, prohibit any disclosure without a court order. In this case, federal law supersedes the state reporting laws, although compliance with the state law may be maintained under the following circumstances. If a court order is obtained pursuant to the regulation, if a report can be made without identifying the abuser as a patient in an alcohol or drug treatment program, or if the report is made anonymously. Some states, to protect the rights of the accused, do not allow anonymous reporting. So that conflict occurs between the federal and the state laws in reporting the child abuse when that person that's committed the abuse is enrolled in that alcohol or drug program. Then the federal laws would supersede what the state laws are. Federal laws governing the confidentiality apply to most of those drug abuse and alcohol programs, so we would try to report the abuse without disclosing anything about the client's drug or alcohol use. Federal laws, again, supersede those state laws. Compliance with the state law may be maintained if the court order is obtained pursuant to the regulations, if the report can be made without identifying that abuser as a patient in the alcohol or drug treatment program, or if the report can be made anonymously. As reported incidents of abuse to other persons continues to grow, a lot of states now have elder abuse reporting statutes, and this requires nurses to report cases of abuse of the older adult. Any agency that receives federal funding, such as Medicare or Medicaid, falls under strict guidelines for reporting and preventing elder abuse. The older adult is defined as any adult over the age of 65, but the elder abuse laws also apply to dependent adults between the ages of 18 and 64 that are dependent, whose mental or physical limitations restrict their ability to carry out normal activities or protect themselves. So when the nurse has actual knowledge that the person has been the victim of abuse. So these elder laws, again, also apply to dependent adults between the ages of 18 and 64. Dependent adults are protected by law from physical or fiduciary neglect or abandonment. Fiduciary means by people that they put their trust in. In most states, a person is required to report suspected abuse, neglect, or exploitation of a disabled adult, and who willfully does not do so is guilty of a misdemeanor. Most states have a statute that declares that anyone who makes a report in good faith is immune from civil liability or connection to the report. So laws require that you report the knowledge and any reasonable suspicion of mental abuse or suffering. Because the state laws vary, again, students are encouraged to become familiar with the reporting requirements of the states where they work. So all patients have civil rights, And in regard to restraints, they have the right to be free from physical or mental abuse and corporal punishment. They have the right to be free from restraint, seclusion, or any form imposed as a means of coercion, discipline, convenience, or retaliation by staff. And they have a right that restraints or seclusions only be imposed to ensure the immediate physical safety of the patient, staff member, or others, and must be discontinued at the earliest possible time. Nurses have to understand and follow the state and federal laws. These are guidelines of the Centers for Medicare and Medicaid Services. Now, regarding restraints, we have to use the least restrictive means for the shortest duration, and verbal interventions or trying to get the cooperation of the patient are our first examples. So first we'll try to verbally redirect the patient. Recent laws in regarding the use of restraints and seclusions have prompted several agencies to revise their policies and procedures limiting these practices. So we're now moving towards a trend of restraint-free environments and finding alternative methods of therapy and cooperation with the patient, which a lot are proving to be successful. Now, medication is considered if the verbal or environmental intervention fails. Chemical interventions are usually considered less restrictive than mechanical. They have a greater effect on that person's ability to relate to the environment, and when used correctly, it's extremely effective and helpful as an alternative to other physical methods of restraint. So some general rules regarding restraints, unless superseded by state law that is more restrictive, effective 10/17/2008, each order for restraint or seclusion used for management of violent or self-destructive behavior that jeopardizes the immediate physical safety of the patient, a staff member, or others may only be renewed in accordance with the following limits for up to a total of 24 hours. 4 hours for an adult 18 years of age or older, 2 hours for children and adolescents 9 to 17 years of age, or 1 hour for a child under 9 years of age. In an emergency, an appropriately trained staff member for the proper and safe use of seclusion and restraint interventions may place a patient in a restraint or seclusion and obtain a written order within an hour, with the exception of a patient-initiated request to be placed in seclusion. Federal laws require that an emergency situation exist, which an immediate risk of harm to the patient or others can be documented. While in restraints, the patient must be protected from all sources of harm. The behavior leading to the restraint or seclusion and the time the patient is placed in and released from the restraint must be documented. The patient in restraint must be assessed at regular, frequent intervals, every 15 to 30 minutes, for physical needs, food, hydration, toileting, safety, and comfort. These observations must be documented every 15 to 30 minutes. The patient must be removed from restraints when safer and quieter behavior is observed. Although state laws may be more restrictive than federal law, they cannot be less restrictive. Tort law applied to psychiatric settings. Torts are a part of the civil law that applies to health care practice. A tort is a civil wrong for which money damages may be collected by the injured party or the plaintiff from the wrongdoer, the defendant. The injury can be to person, property, or reputation. Because tort law has general applicability to nursing practice, this section may contain a review of material previously covered elsewhere. Violence. Bullying has become a recognized form of violence in our society. Nurses may encounter bullying behaviors from nursing supervisors, peers, patients, and even family members. There is some legal precedence for holding professionals liable if they're aware of the bullying behavior that is within their sphere of control and they do not take affirmative actions to protect the known victim. For example, if a patient is bullying staff or other patients at an inpatient facility or during group therapy sessions, the professional has a duty to minimize those harms. When nurses in psychiatric settings encounter provocative, threatening, or violent behavior from clients, the use of restraint or seclusion might be required until the patient demonstrates a safer behavior. According to the nurse in the psychiatric setting, Accordingly, the nurse in the psychiatric setting should understand the intentional torts of battery, assault, and false imprisonment. See boxes 6.3 and 6.4 in your book. Common liability issues include negligence or malpractice. They're commonly used as interchangeable terms. Negligence or malpractice is an act or a failure to act that breaches the duty owed to a patient by the provider. The four elements required to prove negligence are duty, breach, causation, and damages. The foreseeability or likelihood of harm may also be evaluated to determine civil liability, but is not typically a factor in the professional discipline investigations. As a nurse, we owe patients a duty to provide a specific level of care at all times. Nurses that are in a specialized field, such as psychiatric care, are required to have the requisite education, training, and experience in order to understand the theory, treatment, and medication used in the specialty care of these patients. Providers who represent themselves as possessing superior knowledge and skill, such as a psychiatric nurse specialist, are held to higher standards of care when practicing. If a nurse is not willing or able to provide the requisite standard of care that the other nurses would be expected to provide under the same or similar circumstance, then the nurse has breached the duty of care. Breach of duty is conduct that exposes the patient to an unreasonable risk of harm through an action or failure to act by the nurse. Causation is determined through cause and fact and proximate cause. Cause and fact is typically evaluated through the but-for test. But for what the nurse did, would this injury have occurred? So in other words, if the nurse wouldn't have made this move, would this injury have occurred? And then proximate cause or legal cause is more complicated. A finder of fact will evaluate whether or not there were any unforeseeable intervening actions or inactions that were an actual cause of harm to the patient. For example, the nurse dispensed the wrong medication, which fell below the standard of care, but when delivering the medication, the nurse inadvertently left the patient's door unsecured, and that resulted in the patient leaving the unit and falling down the stairs and breaking a leg. Although both nurses fell below the standard of care, Nurse B was the proximate cause of the patient's injury. Even though the incorrect medication may have contributed to the patient's actions or led to harm, the unsecured door was an unrelated, unforeseeable, and negligent action that led directly to the injury. Foreseeability of harm evaluates the likelihood of the outcome under the circumstances. Damages include actual damages, loss of earnings, medical expenses, and property damage, as well as pain and suffering to the injured party. So duty is measured by the standard of care. Breach of duty is the conduct that exposes that patient to the unreasonable risk of harm. Substandard institutional policies do not absolve the individual nurse of responsibility to practice on the basis of professional standards of nursing care. If a litigation alleges that a nurse acted fraudulently, maliciously, or outside the scope of his or her employment, the court may award punitive damages for egregious behavior. Determination of a standard of care. Professional standards of practice determined by professional associations are not equivalent to the standards embodied in the minimum qualifications established by the state licensure for entry into the profession of nursing. The ANA has established standards for psychiatric mental health nursing practice and credentialing for the psychiatric mental health nurse and the psychiatric mental health advanced practice nurse. Standards for psychiatric mental health nursing differ markedly from minimal state requirements. State qualifications for practice provide consumer protection by ensuring that all practicing nurses have successfully completed an approved nursing program and passed the national licensing exam. The primary focus is to elevate the practice of its members by setting standards of excellence. Nurses are held to the same standard of care provided by other nurses possessing the same degree of skill or knowledge in the same or similar circumstances. In the past, community standards existed for both urban and rural agencies. However, with greater mobility and expanded means of communication, national standards have evolved with limited exceptions for remote areas. Psychiatric patients have the right to standards of care recognized by professional bodies governing nursing, whether they are in a rural or urban facility. Nurses must participate in continuing education courses to stay current with the existing standards of care. The psychiatric nurse has a duty to intervene when safety or well-being of the patient or another person is obviously at risk. A nurse that follows an order that is known to be incorrect or that the nurse believes will harm the patient can be held legally responsible for the harm that returns to the patient. If the nurse believes that a physician's order needs to be clarified or changed, it is his or her duty to intervene and protect that patient. The duty to intervene on the patient's behalf poses many legal and ethical dilemmas for the nurse in the workplace. Institutions that have a chain of command policy or other reporting mechanisms offer some assurance that the proper administrative authorities are consistently notified. Most patient care issues regarding physician orders or treatments can be settled fairly early in the process by simply discussing the concerns with the physician. If further intervention by the nurse is required to protect the patient, the next step in the chain of command can be followed. The nurse would then notify the immediate nursing supervisor. The supervisor would discuss the problem with the physician, then with the chief of staff of a particular service until the resolution is reached. If there's no time to resolve the issue through the normal process because it's life-threatening, the nurse must act to protect the patient's life. Medical records help provide us with accurate and complete information about the care and treatment of the client and to give healthcare personnel responsible for that care a means of communicating with each other. The record allows for continuity of care. The record's usefulness in determining is determined by evaluating when the record is read later how accurately and how completely it portrays the patient's behavioral status at the time it was written. The client has a right to see the chart, but the chart belongs to the institution. The client must follow appropriate protocol to view his or her records. If the psychiatric patient describes to the nurse a plan to harm him or herself or another person and the nurse fails to appropriately and timely document the information, including the need to protect the patient or the identified victim, the information will be lost and when the nurse leaves work and the patient's plan may be executed. The harm could be linked directly to the nurse's failure to communicate this important information. Even though documentation takes away time from the patient, the importance of communicating and preserving the nurse's memory through medical records cannot be overemphasized. Besides providing information, the medical record has many other uses. in the course of patient care and treatment. A retrospective chart review can provide valuable information to the facility on the quality of care provided and on ways to improve that care. The facility may conduct reviews for risk management to determine areas of liability for the facility or providers and to evaluate methods used to reduce the facility's exposure to those liabilities. Documentation of the use of restraints and seclusions for psychiatric patients may be reviewed by risk managers. Accordingly, the chart may be used to evaluate care for quality assurance or peer review. Utilization review analysts review the chart to determine appropriate use of hospital and hospital staff resources, as well as staff resources consistent with reimbursement schedules. Insurance companies and other reimbursement agencies rely on the medical record to determine what payments they will make on the client's behalf. From a legal perspective, the chart is a recording of the data, opinions, and decisions made in the course of the patient's care. It's considered good evidence because it's presumed to be true and it's contemporaneous with treatment. The medical record finds its way into litigation for a variety of reasons. Some of it includes determining adherence to standards of care and the extent of patient damages and or pain or suffering in personal injury or professional negligence, the extent and nature of injuries in child abuse or elder abuse, the extent and nature of physical or mental disabilities in disability cases, and the nature and extent of injury and rehab potential in workman comp cases. Medical records can also be used in police investigations, civil conservation or civil conservatorship proceedings, competency hearings, and commitment procedures. In states that mandate mental health legal services or patients' rights advocacy programs, regular audits may be performed to determine the facility's compliance with state laws or violations of patient rights. During the discovery phase of litigation, the medical record is a pivotal source of information for attorneys in determining whether a course of action exists in a professional negligence or hospital negligence case. Nurse charting will often be analyzed to determine the timeline of events, whether nursing staff carried out the physician's orders in a timely manner, and whether changes in the patient's status were acted on or reported to physicians in a timely manner. When computerized charting occurs, nurses must follow the following guidelines. Accurate, descriptive, and legible nursing notes serve in the best interest of the client, the nurse, and the institution. Computerized charting becomes the standard of care. It is important for psychiatric mental health nurses to understand how to protect the confidentiality of these records. Institutions must also protect against intrusion into the privacy of the patient's record system. Concerns for privacy of the client's records have been addressed legally by federal laws that provide guidelines for agencies that use computerized charting. There are penalties, including termination if staff enters records for an area where they are not authorized access. Only staff who have legitimate need to know about the client are authorized to access a patient's computerized chart. Nurses should keep their passwords private and never allow someone else to record under their password. They are responsible for all entries into the records using their passwords. Any charting method that improves communication between care providers should be encouraged. Courts assume that nurses and physicians read one another's notes on patient progress. Legally, if something is not charted, it becomes difficult to prove. Charting also serves as a valuable memory refresher because lawsuits often take place months or years after the care is rendered. In providing complete and timely information on the care and treatment of patients, the medical record enhances communication among healthcare professionals. Privacy of patients' records addressed by federal laws, provides guidelines for agencies that use computerized charting, and it recommends that staff be assigned passwords to identify which staff member has gained access. Penalties are strictly imposed for accessing unauthorized records. Only staff members who have a legitimate need to know have authorized access to a computerized chart. Let's close by returning to the case study patient, Brandy. Brandy is discharged to a homeless shelter after a 10-day stay in the crisis stabilized unit. What nursing care does he need? Is he likely to receive this care? If he returns to the cemetery in the supermarket parking lot, what will his rights be as a patient discharged from a psychiatric unit? What do you predict was included in his discharge documentation? Just some food for thought. Think about it.